Do each of you swear to tell the truth, the whole truth, and nothing but the truth? Starting with you, sir.
Yes, ma'am.
Thank you. And ma'am?
Yes, I do.
Okay. Before we get started, I need to tell you a couple of things about my court and what I need to explain before we actually get to the substance of the case. But first of all, I'm an associate judge. I hear cases by appointment. I've been appointed to hear cases from the Office of the Attorney General, their child support unit. And as such, they give us a digital recorder. I am a court of record. However, I'm not a district court, an elected position with a court reporter. We've got digital recorders for our records. So I tell you that so you're mindful of that. Make sure you speak loud enough so the recorder will capture your testimony and that I can hear it. No shaking your head or nodding when you answer questions. That does not record, and no ahas or ahs. I need more formal yeses and nos. The second part of recording issues is that you heard me announce we were live streaming on YouTube. If you haven't been here before, I'll tell you for the first time, and if you have, please bear with me, is that we are required to be an open court. All the courts are required to be open to the public. And that happened that when COVID started, they started the live streaming on YouTube as a way to allow the public to log in and view the courts that are working on Zoom. Child support courts have continued to work on Zoom with authority outside of the COVID. Now that we're not in that emergency anymore, it's been working for us, so we're still doing it. However, because of that, I'm still required to publish to the public, and we're still handling it by live streaming on YouTube. So I tell you that so that you don't blurt out your home addresses, your social security numbers, cell numbers, something you would not want out on the internet identifying you. And if you say it, I can't take it back. So just be mindful of that. I'm telling you that not to freak out or anything, but just to tell you that's the case, and I have to do it. The other part of it is that once that YouTube is actually recording it too. It's not the official record, but it is authorized. However, once that we're done with the live proceeding here, I'll go into the YouTube app to delete that one as quick as I can so that it's not out there for the public to watch at their leisure. They're only entitled to the live proceeding in the virtual courtroom that's happening right now, not to a recording for later, observing later. So I'll try to get that as quick as I can out. The last part of the recording issue is this court is the only one that's allowed to record. The official records on my recorder do not record. It would be considered a violation of our laws, subject to contempt of court, punishable by a fine and or a jail sentence. So with all that recording issues, Ms. Brown, I know you're used to it, but do you have any questions or concerns on behalf of your client?
No, I do not, Your Honor.
Thank you. And Mr. Hernandez, do you have any questions or concerns about any of the recording issues that I've laid out so far?
No, ma'am.
Thank you. Then Ms. Campos, now will direct my attention to you. You've announced, go ahead and give me an opening statement followed by Ms. Brown's opening statement.
Sure, Judge. So we're here on the state's suit for modification of child support order, which was filed 1/8/2024. Parties have been served already. I think that dad was served. Let me pull it up one more time. He was served February 26th, 2024. And mom was served, I think she filed a request. So she entered her appearance on January 26th of 2024. We've been here to court once before. Dad had requested a reset at that point to this date, as his attorney was not available at that time. So we're requesting to move forward on, I know mom is requesting final orders today, and the other party is requesting temporary orders. We do have agreements as to some issues. We have agreements on dad's income and that he is providing the health insurance for the child, and we have the amounts for that as well. His gross monthly resources are $3,754.40. And he is paying a total of $148 for both dental and health per month for the child. So guideline support would be $607. The state is requesting guideline support, and we are requesting a retroactive start date to start March 1st, 2024. So back to the date of service. That is not an agreement to pay guideline support at this time. Mom is also requesting a non-disclosure of just her phone number and for communication to be through her mother instead, but she's fine with disclosing her address.
And is there not a previous non-disclosure?
There's not a previous non-disclosure finding, Judge.
Okay, because usually when there is one, we can't do it at the original suit affecting our paternity case or the establishment order. But there are requirements for that I'll look at. So if that's an issue, I'll put it on my plate here. So it's a question of guideline support and the non-disclosure. Is that what I just heard, Ms. Campos?
Correct, Judge.
Okay. And Ms. Brown, you want to give me your opening?
Yes, Your Honor. This is my first appearance. I believe I was first involved in the case on first week of June. I was in a jury trial. And it got reset today. It was my understanding that we were going to be doing a temp order. The notice wasn't quite clear if it was final or temp. I assumed it was going to be temp so we could continue to work on what my client needs to get worked on. We do agree, as stated by Ms. Campos, regarding what his gross income is and what the purported dental / medical is. We just kind of guesstimated. We know what he's paying, but we don't know definitively how much of that is attributable to the child. He does work for HEB. They have phenomenal benefits for employees, and I suspect that perhaps it might actually be a little higher. I think the majority of the employees' benefits are paid for by the employer. We do agree that if there is a retroactive award of support, that it would go back to March 1st, as Ms. Campos stated. We do agree what guideline support is calculated at. However, we do not agree that the circumstances warrant, honestly, modification. And if it were to be granted, definitely not in that amount based on my client's excess possession of the child. He basically has had this child, she's 9, and they've been doing it 50-50 forever, even though the original order, he was unrepresented, only gave him minimal rights and duties and standard old standard visitation. They've been doing it 50-50. They've actually been co-parenting beautifully, it sounds like. And then regarding the non-disclosures, my client has no problem communicating with the maternal grandparent. However, we don't want that ordered. There is not violence. They might talk inappropriately to each other via text or on the phone, and it goes both ways. I had suggested perhaps to communicate via app close to keep the tone a little more neutral if things are getting personal. We feel that the suit was filed basically once the personal relationship between Ms. Hernandez and Mr. Ramirez kind of was definitively not going to be a relationship. And there's been a little bit of animosity, I think, out of that. But I do think both parties are good parents and can keep their child's best interest at heart and probably communicate appropriately going forward, because they talk about doctors' appointments, et cetera. And I don't want an order where they cannot be parents that they've been thus far. So our position is we'd like a temp order, Judge, to make sure any calculations are actually accurate. And we do have a tentative available date of September, I think 17th or 13th, something like that, to come back. So it would be very quick to make sure mom gets some finality on her issues. But again, we definitely are not in agreement on the guideline support. And I believe case law is clear that your application of the guidelines is discretionary on a modification. And we would ask that you take that discretion into account after you hear some testimony that this man is a 50-50 dad, and that perhaps modification support is not warranted. Original support was 0, for the record, because even though it said mom had the child, primarily all this kind of stuff, they were always doing a 50-50, and that's what they were still doing. So.
Okay. Then just for the sake of Ms. Hernandez's knowledge, you're here without a lawyer, and that's fine, ma'am. You're representing yourself. You're usually, when there's lawyers, I let them make opening statements because they're going to do a quick summary. Usually when you're the lawyer and you're the witness too, it's easier to just wait till it's your turn to say at one time instead of trying to be a lawyer, make an opening statement, which not sure you know how to do, and or then testifying, and I hear it twice and takes twice as long, which I don't have the luxury to do in this volume court. I also have a case set for 1 that's talking right now, but I thought I was going to get to it at 1, and here I am running behind because of the morning docket. So anyway, because of all that, let's go forward with testimony. Ms. Campos, you get to decide who to start with. It's your pleading, so it's your burden. You'll call witnesses. So just so you're aware, whoever's called, the other one, don't interrupt unless there's a legitimate legal objection, and then you'll get your full term. I don't want you talking while somebody else is testifying, and you'll get the same courtesy. I'll have to stop you if you interrupt or it gets all garbled. Everybody's talking at the same time. Okay, Ms. Campos, you may start.
Yes, I'll call Miss Maria Hernandez as my first witness. Ms. Hernandez, can you please state your name for the record?
Maria L. Hernandez.
And can you please state the name of the child that you have with Mr. Ramirez?
Isabella Isabella Rose Ramirez.
And how old is Isabella?
She's 8.
I'm going to start with the non-disclosure issue. What kind of family violence has occurred between you and Mr. Ramirez?
It's a lot of threatening. It's not been physical, but it's all mental. We have co-parented. Well, you're right, or the lawyer is right about that. But only because he always threatens me if I don't, or he verbally abuses or text message, me a big long paragraph with how shitty I am, how bad of a mother I am, how, he went as far as saying that I raped him. So I just don't understand how you go from talking about, I'm a great mother, to threatening my job, to calling my job, to it's a bunch of threats. And so in order for me not to go through that abuse, yes, I say, come pick her up. Yes, you can take her. I try to enforce the court order. I can call my mom, I can call my dad, I can call my sister, I can call my brother, I can call any one of my family members, and they could tell you the exact same thing I'm saying right now. That in order for me not to get a big old long threatening paragraph through text, I just let her go. That's not great co-parenting. So it's a lot of mental abuse to my daughter. He talks bad about me. He did it to his other kid and her mom. I had to get the counselor last year to call Bella in, because he talks bad about me when she has him, or when he has her. I'm done with the abuse. Yes, it's not physical, but it's mental, and I'm done with it. And I just want to be able to do what's best for my daughter. And I think that having her go every other weekend and on Thursdays, it's what's best for her. And if I have to get a therapist to get involved, so that way I can prove to the courts that that's what he does, then I will. I can't afford a lawyer, so that's why I don't have one representing me right now. But I could, I'm going to see about getting one for this next hearing, because having her 50-50 is going to it's going to do damage to my daughter. I saw it with his other daughter, and it's been happening with me for 8 years. So.
And Ms. Hernandez, when you say threats, what exactly do you mean by threats?
He's constantly just saying that he's going to call my work, and he has something hanging over me. I would have to, there's just so much of it that I would have to send you all the screenshots that I've had. And it's definitely not because we're not together. We haven't been together since Bella's been 3 months. So that excuse has run dry. I don't care that he has another family. I don't care that he's with someone else. Like, that is not my thing. My thing is my daughter, and I put her first, and whatever is best for her is what I'm doing right now. So I keep hearing this. I'm mad, and I'm putting him on child support because I'm not in a relationship with him. I mean, that's been 8 years. Come on. I tried to go and file for child support the first, when she was 9 months old. I sat there in the courtroom and cried and cried and cried, because he just, like, it was going to be hell. That's what he tells me. It's going to be hell if I put him on child support. We've been 3 times. This is the 3rd time. I'm done. I'm not scared anymore. I'm not going to take his abuse. So this is why I'm here today.
Have you ever felt concerned for your safety with Mr. Ramirez?
Only because I don't let myself get close to him, or I mean, like, we usually stay 6 feet apart. My daughter doesn't not like for me to raise my voice or for him to raise her voice. So we try to be very neutral when it's time to pick her up. It's like, okay, I'll see you later. Bye. Have a good time. And she goes with her dad. I mean, I keep it very minimum, the contact, because
Let me stop
I
you.
just don't know.
Ms. Hernandez, I don't mean to interrupt you, but I've got a lawyer waiting in the waiting room that's there on my other case, so I need to, guess she got dropped out and needs to be admitted. Ms. Alvarez, can you do something about that? Yeah.
Yes, ma'am. Yes, ma'am.
Okay, Ms. Hernandez, are you close to finishing that thought, or are you?
So if I agree and I don't argue or I don't say no, he can't pick her up, we are perfectly fine. But the minute I say no, I want to do something, or this is my weekend, all hell breaks loose, and that's basically how it's been for 8 years. So
I was muted. Sorry about that. So moving on to the issues of support. So in the prior order, it was child support was set to 0. Why did you agree to set it to 0 at that time?
Because he would say that all hell was going to break loose, or he was going to threaten my job, and so I just basically was scared and said no. Okay, I don't want it. But as far as him helping me, I have to purchase everything and then he pays half. And he says that because he has a house and he pays rent and he has a place for her over there, that he shouldn't have to provide for my house. Which I get it, but I can't do it all by myself. Isabella needs things for school. I pack her a lunch. I mean, I asked him what I did last year. This all started because last year I asked him for $50 a week. $50 a week to help me with her lunches, and this is where we're at. Okay. So
What kind of visitation schedule have you all exercised? So since in 2016, when the original order was done, what kind of visitation schedule were you all exercising?
He would come over to the house because she was so little at the time. So he would come over to the house that I was renting and he would visit her at the time over there. She didn't start going to spend the night till maybe about 1.5, almost 2 years old. I mean, he would always come to the house. So for the first 2-3 years, it was him coming over and visiting there. We weren't together at the time. But he would still come over and hang out there so he could, because I mean, she was too little. I wasn't okay with him taking her. I don't know. And he was okay with that. So that's how we had it.
Did it move to a 50-50 schedule at some point?
When she started getting older, he just would like her when he had his days off. His days off were random. So he would have her like maybe a Tuesday, Wednesday, Thursday. So I never got to follow the court order. I mean, that was his schedule and I worked with him the best I could. So, we really haven't followed the court order. But it wasn't ever a 50-50. I mean, he had his days off, and that wasn't until she was like 3 that he really took her and had her all that time.
What kind of schedule are y'all doing now?
I am doing my best to implement the court visitation order because I feel like when I don't, if I veer off from that, it's any little thing, it causes him to blow up. So I'm like, I'm going this way. I would let him take her like a Thursday night. He would take her to school the next day or and I would work with him that way because I want him to have her, as much as he can. I do. I'm not that ugly. But so like recently, since we've been disagreeing with things, I've just been trying to implement the court visitation order.
At what point, was it this year that you started trying to implement that standard possession schedule?
I've been trying to implement it for 3 years now.
Okay.
And it just goes horribly bad for me every single time. And I'm going to send you all the screenshots I have to prove to you that it goes bad every time I tell him no.
Okay. And are you requesting final orders today? Yes,
I don't want to have to do this again. I don't want to have to go to court for 50-50. I I don't want to have to deal with this guy any more than I have to. I'm at that point, especially when you accuse me of doing what he said I did. I mean, my God, give up your rights if that's what I did. Press charges on me if that's what I did. I mean, that's ridiculous.
Okay. And are you requesting that support start retroactive to this date? So are you requesting that it start as far back as possible to that March 1st date after everybody was served?
I mean, honestly, if it could go back 3 years, I would go back 3 years because I have not gotten the proper support from him since the day she was born, or 3 months because I left when she was 3 months.
Is there anything else you think judge should know about when making these decisions?
I mean, I just would like for her to consider what's best for Isabella. That's all.
I'll pass the witness, Judge.
Before we move on, Ms. Campos, remind me what the last order was and when it was, because ma'am, you're trying to go back to day one and I can't do that.
I know. I understand that. I was just,
I can only modify from the last order forward.
I just wanted you guys to know.
Let me tell you one part because this is taking too long. 3, it looks like, yeah, if you had a standard possession order and you had implemented it from the beginning or you all stuck with that, and I know you come to the AG's office and everybody means well and blah, 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 and nobody commemorated in there was 50-50, but it also says you can do whatever you all want, subject to if you don't agree, then that's the default.
That's when you follow that. Yes, ma'am, I understood that.
However, I didn't understand, and I still don't understand when it became 50-50. If it ever was 50-50, you're denying that, but I'm not sure because you're trying to talk about day one. I'm trying to talk about the last 3 years, or what was that date of the last order, Ms. Campos?
The day of the last order, and this is the original order as well, Judge, was 2016. So it was signed by you September 9th of 2016.
Was September 9th of 2016. So I heard court 3 times. So I thought there was something else in between that one and this one, but no. So that was a full SAPSR order done at that point?
Correct,
Original.
Judge.
Original SAPSR, not when a paternity established beside the AOP or whatever, I assume.
Yeah, it was, I think there was either an AOP. Yeah, I think it was probably an AOP, Judge.
So September 9th of 2016. So we're talking about 8 years ago,
Yes, Judge.
or it's going to be 8 pretty soon. Okay. But I have no ability to change the custody order here today. None whatsoever. The state filed a modification of support. So I get to hear the facts that are happening now and decide what is happening. If y'all are disputing it, you say it's not 50-50. He says it is 50-50. Then I have to do all the calculations on what does that mean and who really has more and how much more, whether it's a lot more or very little more, whatever it is. And then even if I decide all that, guess what? Ms. Brown may not agree with my decision and may appeal me and go to another court, and you're stuck with whatever the legal process hands you, Ms. Hernandez. You don't get to decide what happens here today or decide that you're never going to see this guy in court again. That's not the standard. The standard is if you want a custody fight, you might have just bought yourself one if you're trying to implement standard. And it's the old standard, which is a lot less than the new standard that happened a couple of years ago. And then Ms. Brown, on behalf of Mr. Ramirez, can file something else, not just come in here on the child support modification. And you're going to be up in another court doing a custody modification for a different judge to hear you. And even if he plays out with witnesses and more testimony and more evidence, whatever, on what it should be. It should be 50-50 or it should be the standard possession. And then child support goes along with all that. So I'm trying to figure out what I could possibly do today without hearing a custody fight, because this is not a custody fight. But I know you're going to argue possession, Ms. Brown, and Ms. Hernandez is arguing it too. So you just bought me a factual dispute on what's actually happening, which I don't know if I had the time for or not. But Ms. Brown, you still are entitled to cross-examine. Is there anything you want to say, either lawyer, Ms. Campos or Ms. Brown, based on what I just indicated?
Well, again, I would just argue for a temporary order, Your Honor, and we can take this back up at the end of the month, or I can file an objection with a counter petition, and we just remove it all over to district court, which is what I think is probably more appropriate, rather than you make an order and then have to have it redone, undone. And then
Ms.
Ms. Campos would just be consulted as she needs to be consulted for the state's interest.
Ms. Campos, you the filed the mod, you haven't heard, or maybe you've talked to the parties and you know better than I do. I don't know if you can, well, you can't rule for me, but on the other hand, is there an actual dispute on the actual possession and how much it is, whether it's truly 50-50 or not, or that's what I'm gonna get here?
Judge, it does sound like there's a dispute on the possession, but there's no pleadings filed for visitation at this point. So we're not requesting that anything regarding that be heard. We just would request that guideline support be
No,
assessed.
but I can't consider actual circumstances because y'all are the ones that create this sometimes when people don't have lawyers and people are said they're doing 50-50, but that's not what the order says. And now it's a huge mess. Now, I don't know if you did or you didn't, or how, to what extent it was or it wasn't way back when, 8 years ago, 7 years ago. Good Lord. The other case is asking for help. The lawyer in Mr. Nelson's one is asking for help. Can somebody handle that, Ms. Valdez, or give it to somebody? Thank
Yes,
you.
I'll let them know.
Okay. So I would have to hear what's happening and try to base support, whether it's more than standard or if it is 50-50. That's what you're asking me to do here today, so I can set child support. I don't think it's as easy as the state thinks and Ms. Hernandez thinks that I just trust that it's going to go to standard. So now I have to order the full support. If that's not what's been happening, and Mr. Brown is a very good lawyer, whatever I do, if I side with you guys, I can see the appeal coming right away, which is their right. So, but I haven't even heard the evidence, so I don't know yet, but that sounds like it's going to take another hour or so. It's not going to be a quickie temporary mod thing, but I guess the other cases are insisting on anything yet. I'll keep going. So let's go with Miss Brown. You have your cross-examine, Ms. Hernandez.
I'm ready, Your Honor. Hi, Ms. Hernandez.
Hold on again, Ms. Brown. Ms. Valdez, do I need to do something with the other case right now with one of the lawyers in my courtroom?
Sir, Miss Nichols went back into that breakout room. If you join your breakout room, she should be in there and she'll be able to help you.
Thank you, Mr. Liansky.
My apologies. I did not mean to interrupt.
No problem. I just want to get you to the right place if you don't need to be here. There we go. So, Ms. Brown, start all over, cross-examine Mr. Hernandez.
Ms. Hernandez, so back in September of 2016, I believe it was, when you got your order entered, you had stated that that you were doing the co-parenting and the sharing of time based upon threats that you were receiving and have always been receiving from Mr. Ramirez.
Yes, ma'am.
So this is not a new issue. This was going on at the time of the final order as well, correct?
Yes, ma'am.
But at that time, you did not seek non-disclosures, correct?
No, I didn't. I should have.
All right.
I just
And,
wasn't getting physically abused,
okay.
so I didn't know. I didn't
All
know
right.
the meaning of that, I guess.
Okay.
I don't.
Just, well, we got to keep it quick and just answer what I ask, because otherwise we'll be here all day. The judge doesn't have time for that. All right. And you were talking about the threats that he was threatening to call your work about something. And is it because you have warrants for your arrest? Is that what he was threatening to do, was report that to your employer, or what?
No, he was not trying to do that. He was trying to get me fired.
Okay.
And I have proof. I have proof of that.
Okay. That has nothing to do with your child, correct? No threats about your child. You were getting along.
It has to do with me being able to keep my child in a home. So yes, it does have to do with me, my child. I mean, I have to have a job.
And back in 2016, September of 2016, isn't it true that in April of 2016, the two of you executed a sworn affidavit that you were going to co-parent equally and do 50-50 possession, that you all signed and had that notarized before you even did your final order in September of 2016? Do you remember signing that?
I do remember signing that under duress. Yes, I do.
Okay. So that has been the operating belief of Ms. Ramirez since 2016.
That is what he made me sign. So yes.
Okay. All righty. And then you did say that you've been, since the date of the final order, maybe even before then, but we don't talk about before then because it's not relevant. But that you basically buy everything for your little girl that she needs, and then you give him a request, say, hey, you need to pay me for half of this. It's kind of what how you
Yes.
guys have been doing it. So he has been financially contributing to the support of your child on specific items that you request money for only, correct?
Like the school clothes. Yes. Mhm.
Okay. And I did hear that you're requesting that maybe at a minimum he can not only does that for you, but that he would split those school lunches too, perhaps
No,
are they
ma'am.
$100 a week?
No, I said that I asked him for $50 a week, so that way that would help with school lunches, and he refused to give me that.
Okay.
So that's what I said. Yeah.
Okay. But if he were to pay for half of all of the money you're putting out of your pocket for your child, that's how you've been operating, with the exception of him not reimbursing you for school lunches. Did you ask him?
If I asked him for $50 and he refused to do that, I didn't ask for anything else.
Okay. And when was the last time you asked him for that $50 per week?
At the beginning of last year.
Okay. And that's when you made the decision, I'm going to need to go to the AG's office and get supports if you're not going to give me anything to help out?
Yes.
Okay. So at that time, $50 a week was what you were asking for from him.
To help me with lunches only.
So that brings my question. Are lunches $100 a week?
No, that just covers snacks and whatever, I buy her. I pack her lunch every day, and it's pretty, I mean, I don't know what, I'm
You
not
buy
going to go into
lunches.
detail.
No, I got you. You buy lunches. I was thinking you were
I
paying
buy
for them.
I buy the stuff to, yes.
I thought you were buying them at school, and I apologize. That's why I thought they
No,
were free.
no,
She gets
she's a picky eater, so we pack her lunch. Yeah,
She gets good lunches from mom. Okay.
she sure does.
All right. And then you did indicate that you guys have been doing a thing where when Mr. Ramirez is off work, that's when he sees the child. Pretty
Yes,
much.
because he didn't have anyone else to watch her, and he didn't want to leave her with his girlfriend, I guess. I have no idea. So he would watch her when he was off.
Okay. And you'd agree with me that he's off 3 days a week. He only works 4 on.
Yes, that was what his schedule was. Yeah.
And you actually work 2 jobs, right?
Yes, ma'am.
And your primary job, how much do you make per hour at your primary job?
I don't think that's relevant. I mean, why would that be relevant?
Your Honor, can you instruct her to answer the question, please?
It may not be for the purpose of setting child, well, it might be because
It's 50-50.
what I do if on a 50-50, if he makes a lot more than you do, I do this offset. And I think most judges, a lot of judges do the same thing, where it's not full guideline, because if you're splitting possession, you both have equal responsibility. However, if he makes more, it might be necessary to know what your income is, to do an offset, that he still owes you some, but not necessarily guideline if it's a true 50-50. So yes, it is relevant, Ms. Hernandez. I will order you to answer the question.
Just hourly, ma'am. That's all we need. Not your annual.
23 an hour. I don't know. I get paid salary, so I would have to calculate that, and I don't
Well,
have
then what's your
access to my
salary?
computer.
What's your salary
It's 59.
per gross per year? Okay.
Mhm.
And then that is your primary job, correct?
Yes.
And you have a secondary job. You work at Boot Barn.
Right, but my hours vary, so I'm down to one day a week, 4 hours a day. So I'm not making much on that. I'm not giving you that information. That doesn't count. I can't depend on that because the hours vary. That's
How much do you make per
$10
hour?
an hour. $10 an hour.
Okay, gotcha. Just not very much. I gotcha. All right. And so when you do work at Boot Barn, you do allow Mr. Ramirez to have time with your daughter, correct? He watches her for you?
If I don't have anyone here to watch her, then yeah, I do.
So there's weeks where he would possibly have her 4 days a week if you're working extra, like you sound like you work extra sometimes. The Sundays you work, is that typically the day you work?
I do work Sundays, yes, ma'am. I
At Boot
haven't
Barn.
worked a Sunday. I haven't worked a Sunday in a long time. So, like I said, it's been 4 hours a day, and it's on Friday night. So,
Friday night. Okay. All right. And have you guys discussed whether the health insurance for your job is better than his health insurance, or does he have the better premiums? Do you think cheaper?
I don't
You don't
know.
know?
I
Is
don't
health
know.
insurance available to you at your job?
Yes, of course it is.
And are you already paying for a family plan right now?
No, I pay for myself and that's it.
Okay, so you don't currently have coverage for any other children or anything like that. Just
No,
yourself only.
all my other kids are over 18.
Okay. That's the other question. You're only obligated to pay, if you were to pay to child support, it would only be for your little girl. That's it. You have one
Okay.
child you're financially responsible for, correct?
Right. All my other kids are over the age of 18.
Okay. You're probably still supporting them, but don't have to.
That's right.
Okay. All right. Alrighty. And let me see what else. And you said that you want to have the judge consider what's best for Isabella, correct?
Yes, ma'am.
And your daughter, she doesn't have any idea about you not wanting to send her to her father's, right? You don't discuss that with her, do you? You just let her go.
Correct.
Okay. So she thinks that in her happy life that she gets to be with you a lot during the week and with daddy a lot during the week, right? She's happy
It's
with
not. Yes, she says that she wished she was a twin, so that way we wouldn't have to do this back and forth thing. Yeah.
Yeah. So she likes to be with both of you equally. That's great. Okay.
Of course.
I'll pass witness.
Do you have further examination, Ms. Campos?
No, Judge.
Ms. Hernandez, technically, you're here representing yourself. Now that you've been cross-examined by the lawyers, you have the right to make any statement in your case without it being a long narrative. Just anything you haven't been asked that I haven't already heard. Something else you want to add to your picture?
No, I'm okay. I don't want to prolong this any longer. I know you have other stuff to
Don't worry
do.
about me. I'll worry about me. I do this every day and they pay me.
Well,
But I'm trying to give you your full day in court, so you can't walk away and say, the judge had to cut me off. I didn't should get to hear all of it. So tell me now, if there's something else you haven't said, I heard it once, you don't have to repeat yourself, something different and new that you think I should hear.
no.
So really, honestly, right now, before I have heard anything from him, you do not think it's a 50-50?
I don't think it's a 50-50. I think he has her like he would have her on a weekend, like a Friday, Saturday, bring her back Sunday. So I wish that it was a 50-50, but it's not.
Well, that's totally opposite of what you said so far. Then, did you mean that? You wish it was a 50-50? What was that?
As far as the visitation, I wish that I can let him have her more. But that's not how things go. I have to have her during the week so she can go to school. I mean,
Well, then let me ask this. Even if you think it's not 50-50, are you saying it's every weekend? Because the standard
So
visit
when you
is every other.
when you
first,
say
third, and fifth.
yeah, when you say 50-50, are you talking about visitation? Are we talking about 50-50 with money? What are we talking about?
No, we're talking about possession. How much is the child with you versus how much the child is with him? And things have changed a lot since your first order, including it's a different standard possession order, which gives a lot more. But y'all signed something in writing, apparently. I don't know if it was notarized or not, but
That was notarized at a parking lot in a parking lot at a store. I mean,
signature, and it was notarized. They said it was your signature. Agreement.
it is my
Toilet
signature.
paper and dining room tables or whatever.
Okay.
Kleenex. I mean, I'm just saying, if you sign
Again,
you
I did sign it under, being threatened constantly, so.
I heard that. Okay, I heard that it's under duress. However, no court has found that it's been under duress. You're just saying that now, correct?
Because I tried to do the best I can to not file anything extra, not do anything extra, not be extra. So,
Let me finish my question. That you don't think it's 50-50, but I was trying to get to the point, was it every weekend that he has the 3 days out of the 7 versus 4 days out of the 7 versus whatever? Or is more than 2 weekends a month, the first, third, and fifth, and not every month has a fifth weekend? And I'm not sure how many months there are with those, but it might be more than 50, but not quite just regular visit under the standard possession. That's more specific, and I don't even know what that is, although I think I just heard it, the advanced family law, it's more of a lot more, it's not 50-50, but only 60-40 or something else. It's not 50-50, but it's still a lot more than us old lawyers or family law judges were used to in the old days. So, Mr. Hernandez, can you put a number on it, a percentage on it? How much, if you counted the hours on the day on each and every day versus the hours you have versus the hours he has? Well, if it's not 50-50, do you have any idea what it is?
No, I don't.
And you're convinced that it's not more than a standard possession order would have given him? That's what you're also saying?
I let him have her every other weekend and on Thursdays, and he had her all the summer. All the month of June. I'm trying to go by the court order because if I don't.
I know what you're trying to do. I'm not I'm what is happening now, not what you want tomorrow, because that's what you want. What's happening now, the possession, the difference in the possession. And you're saying it's not 50-50, it's every other weekend with an extra overnight or something, Thursday nights.
Mhm.
Is that
Yes.
every Thursday?
He's allowed to pick her up every Thursday. Yes,
You split holidays like along the lines of
we do. He'll have her like Christmas morning, and then I'll have her Christmas afternoon, or she'll go over maybe Christmas Eve, and then because he's got a little boy, he wanted her to wake up there. So I do work with him, but as far as her staying over there the whole Christmas holiday, it wouldn't happen. It would be like a weekend thing.
And what about the summer? Do you do more than just the 30 days in the summer, or you do?
So this is the first summer that he had her the 30 days in June. He's not been able to have her the whole summer because of his work. And I work from home, so I was able to keep her here. And,
Okay.
if he,
What about spring break? Do you alternate where you get the whole week and he gets the next year the whole week? Anything for spring?
no, that's never happened. No, he's not had her the whole. No, he's not had her the whole spring break. Again, because of his work, he might have had her half the week because he's off that last half of the week. But he's never had to, or he's never taken her a full week because he didn't have anybody to watch her. Both him and his girlfriend work. So he would have her the last week or the last couple days.
You're on spring break. What about Thanksgiving? You don't like, I think now they let the kids off the whole week. Do y'all take turns with Thanksgiving, whether it's the long
No,
week?
I have her the whole time.
Everything.
Unless every Thanksgiving since she's been born.
What about?
And she'll go like the day of or something like that.
The Christmas 2-week, that's a 2-week holiday period usually, or sometimes it's a few more days or a few less days, but y'all don't split it 1 week with you before Christmas and him after, and the next year you reverse it?
No, ma'am, we don't. Again, his work schedule, so he's never had her like a complete whole week. Like this is the first year that he had her the whole summer. So, not the whole summer, I'm sorry, the whole month of June. This is the first year. It starts Tuesday.
Okay.
So he brought her back the 31st, June 31st, or whatever that last day was.
30th.
Yeah, 30th.
You had her June, now you've had her the month of July and August. What's going on in August?
Or was it, I'm sorry, was it July that he had her? Whatever month he was supposed to have her, he had her that month. And then, brought her back the 31st.
You don't remember if she was with him
it was July. I'm so sorry. I misspoke.
Okay. And then you're planning you had her all June, and for August school starts, but you've already had her the first few weeks before school started? Or is it
yes,
still
ma'am.
The long weekends in August?
Yeah, he'll have her for the weekend. I let him have her on the weekends.
And that was true for your month of June. He still saw her during the weekends.
Yes, ma'am.
Okay. And I may have missed something, but any further cross-exam of this witness, Ms. Campos?
No, Judge.
Or Ms. Brown?
No.
Okay. Then next witness, Ms. Campos.
I'll go ahead and call Mr. David Ramirez. Mr. Ramirez, can you please state your name for the record?
David Ramirez.
Thank you. So there had been an affidavit, I think, of some possession that y'all had signed. You said that someone said prior to the last order. Is that correct?
Yes, ma'am.
Okay, but so that occurred prior to the 2016 final order ordering the SPO, is that right?
That's correct.
Okay, understood. Are you in agreement with what Ms. Hernandez said about the visitation that you've been exercising
No, ma'am.
recently? Okay, what kind of visitation have you been exercising in more recent years?
Okay, so for documentation, for the documentation and calendars that I do have, we had split custody since my daughter was 3 months. Me and Miss Mary Lou, we weren't even a couple. She moved into my home, which I still have a copy of the rental contract. Um, she had moved into my home when she found out she was pregnant. We were not dating before that. The situation on how my daughter occurred, I wasn't going to bring that up. She brought it up.
Well, I know,
Don't
but
bring
I
it up.
told her it wasn't relevant and
Right.
day
I
one.
wasn't going to bring it up. I'm not
Okay.
lying about it. I mean, I
That's
have
not
the doc.
even on my table. Other than the document that y'all signed, I would look at
Right.
if we had it, but okay. Start over with your question and make it real clear what the time period I'm looking at, Ms. Crumples.
Mr. Ramirez,
Yes,
is it your assertion that y'all have been exercising a 50-50 possession schedule?
The
In more
50-50
recent years?
schedule every week, yes.
Okay, and what does that look like exactly, a 50-50 schedule?
So I have a set schedule. I'm off every Thursday, Friday, Saturday. And so I would always pick up Isabella every Wednesday when I got off of work around the latest would be like 4 o'clock. So I would
Okay.
pick her up from 3 to 4 o'clock in the afternoon. And I would have her all the way till Saturday. And then if she worked the boot barn on a Sunday, which she was majority of the time for I think a whole year, I kept her all the way till Sunday. And then I would take her back either when she got off of work or I would take her back to the grandmother around 6 o'clock, 6:30.
Okay. Did that schedule stop at any point recently?
Up until she filed for the child support is when she tried to withhold some days out of the week. So I wasn't no longer allowed to have the 3 to 4 days a week. She cut my time down to 2.5 days a week. So
Okay. So since this case has been filed, it's been less of a 50-50 schedule because she's denied that from you?
So she tried to establish the standard order for that first week, where she kept her that weekend. And by that following week, Isabella was back with me in the middle of the week for that weekend. And so the following third week after that, Bella was back with me from Thursday, Friday, and I took her back Saturday. She wanted to try to alternate the weekends because she likes to go and spend time with her family, which is cool. And we never argued about that. We've always been flexible with Isabella, like when it comes to like birthday parties and it's whatever Bella wants to do. We've always kept it at that. We've always allowed her to kind of make these decisions. So if she wanted to give her mom an extra day or, one of my days, I would let Bella stay because it's just what she wanted to do. But so majority of the time, I at first before I was served in March, I was up to 17 days a month. Now, after I got served here in March, my days had cut down to 13, 14 days a month.
Okay. And so last week, how long did you have Isabella?
She was with her mother last week. They had went somewhere, so so she was with her mother last week.
I see. And then what about the week before that?
She was with me. She had just came off of being with me. I think it was how many days were we so she said that I can take her for the whole month of July except for the 18th through the 21st because they had a beach trip. So I was okay with it. I wasn't gonna say no, So and then before that in June, I'm sorry, I had her I think it was 18 days out of June.
I'm going to pass the witness, Judge.
Ms. Brown, your witness.
Mr. Ramirez, do you have any problems communicating with the mother of your child in a appropriate manner when you're exchanging or talking about your child?
No, we don't. I mean, but we're humans, and sometimes, we're having bad days and we miscommunicate, and yes, sometimes we get overly like aggressive in our communication, and we do curse, but it's never in a conflicting situation where Isabella has always been put in the middle. We tend to leave that part of our relationship out of it, and it maintains the personal issues if she has with me or me with her, and we
If the
kind of
court
separate that.
if the court were to order you to only communicate with Ms. Hernandez regarding your child issues, only your child issues, and to do so in a non-threatening, harassing manner, would you be able to follow that order at all
Absolutely.
times?
Yes, ma'am. Absolutely.
Okay. By phone, verbal, in any manner, you could behave
Yes, ma'am.
essentially.
Yes, ma'am.
All right. And so it is your testimony that you have since the entry of this order back in 2016, you actually, holidays wise, is it true that you only got to see your daughter for part of a holiday, or did y'all split those vacations up?
Ma'am, no, ma'am. We had split those days. So if Christmas was coming about, her mom does a tradition on Christmas Eve where she reads the book of Christmas to all the grandkids. And I've always, respected her tradition. So when they were done reading the book or so, if Bella was still up, I would pick her up at night. If not, I would pick her up that early morning on Christmas Day.
Okay,
So
so you all don't do a block for Thanksgiving or a block for Christmas or a block for spring break. You all just
no,
continued on with your so many
right.
days per week you got her.
Yes, we just continue straight on. And the holidays, we've always prepared before them. So if we knew Thanksgiving was coming up, we'd always try to figure out where she was doing Thanksgiving at and where I was doing it at, and we'd meet in the middle. So she would have her that morning, and I would go pick her up that either that afternoon or evening to the night. So my daughter was able to enjoy both families,
Okay,
and
and
it's
you've
always
also
been like that.
Okay, you also heard Ms. Hernandez state that she would ask you to split costs for your daughter on more than one occasion to help out. She would purchase an item and then you would reimburse her for half. Is that true?
Um, that is a semi part true. When we came up with our agreement in 2016, we both discussed, equally meeting in the middle to both provide for this child under the circumstances on how we had this child. We both equally were in agreement on how she should be provided. Now, if one parent falls short, we've always kind of been the teamwork where I would cover it or she would cover it, and we always kind of just relied on each other because I mean we've actually been really great co-parents up until recently, and so that's why I find this situation a little bit conflicting. But we
Since you
we
got
tend to. I'm sorry. Go ahead.
Okay, since you got served the paperwork, have you provided any financial support to Ms. Hernandez, like paying for half of anything since March of this year, or did she quit asking you at that point?
When she initially asked me for the $50, she was trying to get me to reimburse her for $200
No,
spent.
listen to my question. Listen to my question. My question was, since you got served March 1st, you got served in
Oh
February, but
no,
March
no.
1st, you've not paid her any halvesies on anything since March 1st.
Just dentist bill, um, co-pays, doctor co-pays, and I provided medicines.
Okay, so
She has
nothing other than medical.
no. I asked her
Okay.
about the Bella school clothes, but I never got a response from her because we purchased the school clothes and we split it evenly. We split it evenly. So,
All
but
right.
I never got a
Okay.
response when I asked.
All right. I'll go ahead and pass witness.
Okay, technically, Ms. Hernandez, you're acting as your own lawyer. You have the right of cross-examination. Now, I won't let things get ugly and no name calling or making statements at this point. This is not the time for it. But do you have any questions for Mr. Ramirez from your side viewpoint that you think you need to ask and have them answered before me?
No.
No, okay. I still can't get a feel for if it's really 50-50 or not, just because you included it was 17 or 8 days in one month and 13 in another. I don't know how much of a day counts for a whole day, whether she had, the child's in school and then you get her 3, but it counts for the whole day when you really only have her whatever.
Ma'am, may I speak, please?
Well, okay.
So an account to me not being able to give my full testimony, I just want to state, for the record that I have never threatened this woman. The issue about her job, she told me she was going to try to take my house from me. So yes, I was being in a petty move, and I told her, I said, okay, well, I'll take your job. You know, there are messages that I do contain about racial stuff that she had said about people at her job that she was scared that I was going to give to her job. I never did. I told her when I was upset when we were arguing one day, but I haven't threatened her with that. I have every single phone right here, and they all do work since the day that me and her been together. I have over 8 years of text messages of our weekly visitations. I have for the past year, I have up to all the way till 2018 calendars here that all determine how many times I pick up Bella every week. And I know.
But like,
And
are you telling me that, yeah, even if you have all that documentation, does it say Thursday, Friday, Saturday, and then there's a skipped weekend, and then it's the following Thursday, Friday, Saturday, and maybe the Sundays where she worked, and then see
Mr.
what-
Ramirez, I think she wants to know if you had the child every week for half of the week.
yes,
Not every other, but every week.
yes, this is just a way that I documented it. So I have her every week, as you can see. The blue indicates when I have Bella.
what
It's
month and
based off
year is
my
that? I
days
can't
off.
see that part.
I'm
What
sorry.
month and year is that? No, I can see the blues and the number, the days, but I can't see the date and the month.
Well, this one was from, just to indicate, this is like an example from September, was it September 2023? So, I mean, the calendars all indicate just as they are. You know, I have it where if it's half a day is when I pick her up off of work. When I work that day, I pick her up half that day, and then I'll have her those days off. And then the days off that are blank is when she's with her mother. So
What's the W stand for? What is that in the white?
I work, the W stands for work.
Oh, that's when you're
I,
working.
yes, ma'am. I work those days. So the days that are highlighted on all these calendars are the days that Bella's with me.
And
Um,
so the mom has them on those W's
the
because
days that I do work. Yes. So if you go back and look, if you can indicate only work basically right there. I picked her up half that day. So I got off about 3. I was off that Monday, Tuesday. I worked Wednesday, Thursday, off Friday. And then she had her back on Sunday. So all the calendars I have and the text messages that can coordinate this schedule, it shows that I have and always have had Bella on a weekly basis.
you have January, February, and March of this year, 2024.
Yes,
Well, this is
I'm
that
going. Yeah, I have them all in screenshots. So the ones from 2024 from March right now, March, April, I'm taking the screenshots and I'm placing them in the calendar. But my schedule, I have a set schedule, so it doesn't change. We bid on schedules at my job, so basically based off of performance. So if I show up to work every day, I land on the list of like 10 people, and if I land on a good spot, I pick the better schedule. And so my schedule for years has always been every Thursday, Friday, Saturday off. And so that's how we always went by that schedule. And if I call in or I don't go to work, then of course I lose my spot and the schedule will change. I would have to pick a different.
So do you have January and February then if you don't have March and April?
Um,
'Cause I'm still trying to figure out, because I saw this wraparound thing, not necessarily every Thursday, Friday, and Saturday, and maybe even Sunday.
it doesn't look like I have I don't have January marked. I started, like I said, I'm going back through all the screenshots that I have to go all the way back and backtrack it in the calendar. But
So your answer was what? That you do have the child half a week every week, or 3 days
yes, ma'am.
a week?
Yeah, every week, ma'am. She tries to enforce the standard like if she'll try to enforce the standard order, it's not just me that of course I'll be upset with it. I mean, I've had this child every week for 8 years. So who wouldn't want to be upset by someone now saying, "Oh, you can't have her every week"? Like it's a change up that you're not prepared for. And so I just don't get upset by it. You know, our daughter gets upset by it. And so she's not understanding why things are changing. Knows what child support is because she's experienced losing her sister in court cases that I've had with, you know, my oldest daughter's mother. So, you know, of course, my daughter is aware of what's going on. but she doesn't understand why time is being withheld, why me and her mom are no longer talking, why we're not friends. So it's causing yes, it is causing a dysfunction in a lot of things. Change this up and go back to the standard order. So how do you tell a child who's almost going to be 9 years old, you can't come every week no more? Now you have to come every other week. It's just not fair to her.
Yeah, those are arguments for your lawyer to make later, but I'm still, she said one thing, you said another. Now, how do I resolve that? That's what I get every single day, and I'll have to figure out something. But can you tell me why I should believe you versus her that it's not every week?
If she can provide documentation that states that it's not every week, then you can believe her. I'm not being disrespectful or rude, but it's
No, but
easy
you haven't provided it either. It's your testimony versus her testimony over the last few months before the lawsuit happened, I guess. What's happening now? And I guess the only thing that would sway me either way is maybe that notarized documents, even if I don't have it right this second, if the state or Ms. Brown can provide it and either read it to me if it's short enough or send it by email.
I can if you
I
share,
have it right here.
we can share screen. You just put up to your computer your picture and let's just see what it was that they all signed.
Yeah, but you can't zoom in on the language so I can read it.
I can share screen, Judge, if you want.
Yeah, I may as well look at that now and get that part over with. Let's see, can you screen share? I have to
see.
change the setting here.
I'm just pulling it up so it's showing here. Hang on. Contract payments.
And just to add a comment to this this paperwork,
Just wait till she asks you a question, okay? Let's see. All right. Am I getting to share yet or no, Judge?
I did do the setting. I changed it. I hope.
Okay, here we go. So this is in my document keeper, so that's why it looks a little goofy, everyone. So let me get ourselves off the screen over here. Okay. So
Can you
can everybody see it?
zoom in just this? Well, okay, I think I can.
He says David Ramirez, father, and everybody can see that.
Yeah, parents of the child, let's see, state and agree with the parenting visitation custody plan that the parties shall exercise, and have a recording, so I may as well read it. 1, that the parties shall exercise joint or shared physical and legal custody of their minor child, Isabella Rose Ramirez. Both parties will have equal visitation rights all year round. Birthdays and holidays will be a shared time agreed on both parties of when, time on those particular days. Minor child will be able to stay nights, weekends with the parent that the child will be visiting with. 2, that neither will pay child support to the other. That we declare that we are the mother and father of the above child, and we agree that as parents of said child, we shall share equal parental responsibility for the child, and all above is agreed upon. And it does have what's supposed to be a date. I see names, signature,
And there's the notary.
notaries on what day was that? 16th day of April, 2016.
Correct, right there.
Did anybody ever file it in a court file?
I
No.
don't believe they did.
Okay. Thank you, Ms. And that's all of it. You scrolled through page 1 and 2. Well, was there a page 2? I just saw one.
Two was a blank. I think it's because my office just is the
Okay.
back side of the page.
That
Do
part.
you want me to go ahead and stop share, Judge?
Yeah, that would be fine. Thank you. Okay. We're still on Mr. Ramirez. Ms. Hernandez didn't have any cross-examination. You said you have no questions, Mr. Hernandez?
No, ma'am.
Ms. Campos, anything further from Mr. Ramirez? For Mr.
No,
Ramirez?
Judge, I'm ready for my closing.
Mr.
I'm
Ramirez, you
sorry,
wanna
real
show
quick,
me
but
something
you
that I
wanted
don't
me
know
to
if
show
we're
you.
doing?
David.
If it's just your y'all's ugliness to each other, I really
No,
don't.
no, it wasn't. It was February. You asked for February possession. So,
Okay,
like
what
I
is-
said,
What are you gonna say that says? What are you
Well,
trying to?
what I'm trying to say is like when you asked for if I had her January, February possession, that's why I was telling you I was screenshotting them and putting them back to the calendar, because if I show you February, it's just a lot of like me and her. We're not arguing. Like if you read the messages, you can tell we were really good friends. So if I go and show you the messages, she'll tell me pick her up from school. I picked her up from school. There's my daughter right there outside the school feeding the chickens. And it's all like that through January, February. If I'm picking her up every week, it all states it. So I
But
would
you
have
don't
to,
know how many days that is without us taking the time. Are you taking the time to count them to right now?
like I stated, I would have to go up the screenshots and mark them. But at this time, we were always 3 to 4 days a week before I got served back in March. So that's when it changed down to 14 days.
Okay.
Before then, I was at 17 days, 18 days a month.
Okay, thank you. Ms. Campos, you rest. You don't have any other witnesses or rebuttal from Ms. Hernandez or anything?
No, in state rest, just a brief closing, Judge.
Ms. Brown, do
We
you have?
rested up close.
Ms. Hernandez, you're acting as your own lawyer. Do you want to reply to anything Mr. Ramirez said or anything else to present?
No, ma'am. Thank you.
You said it's not half. He said it is half. Can you reply to that part, that it's every week, not every other week, like you said? Can you reply to that?
I'm sorry. Can you repeat yourself?
You've
don't
told
understand.
me it's every other week. He's told me it's every week, the splitting of the week, the 3 to 4 days. And I don't know. I wasn't there. I'm not reading your calendars and your texts and your this and your that. And I honestly don't know. So is there something that you think you can say to reply to that at this point?
No, I don't know what to say about that. Yes, he saw her every week. I tried to do the best I could to work with his schedule. I enforced the child support visitation order because I was constantly getting told stuff, or my daughter was getting told stuff about the child support. So I just tried to do the best I could to ensure that, my daughter wasn't coming home in her own distress, So
Okay. So you telling me he did see her every week, several days?
Yeah, he would see her. Yeah, he would see her every week.
When did that
there's
stop?
I think when he started threatening me and telling my daughter
I'm
stuff.
asking you for a date, not why, but when.
I don't know, since last year in November, maybe. I don't know.
Where you didn't let the child go, you didn't ask him to take her anymore?
I just tried to I don't know. I just tried to, like I said, give her a little bit more structure. I told him that I would let her go every weekend, but I would have her during the week so I could take her to school every day. Because there was times where she would go during the week and he wasn't taking her to school, or they wouldn't wake up. So I said, let's just do every weekend. You could pick her up if that's what you want.
So when did the every week stop? You still haven't told me. Was that March when this thing got filed, or?
No, it was not in March when that thing got filed.
When do you?
I don't know. Maybe in January, because I think it was in January, because last year in December I was like, I'm not doing that whole
so
during
you
the week
wanted to
thing.
stop it.
Is what I would tell him.
You get every other weekend.
Ma'am, I've always wanted it this way, but
you wrote a notarized statement that you agreed to something, whether it's under duress or not. You take it to another court to decide that, but it's not this court. But you said you were following it until when? January of this year, December of last year, when you got fed up?
I will say January of this year.
And you did it unilaterally. You didn't put it in writing. Y'all were going to stop doing that.
No, I just didn't agree with him taking her during the week. So I said, we're going to follow this court order because we're arguing too much. So that's why I followed the court or the visitation order, because that's what it's for. If we can't agree on something, then we fall back on that. So that's what I did.
Well, that would normally be true if there was nothing in writing, notarized and dated, and trying to make it formal. Even if you're not lawyers, you did the best you could. I tell people, put it in writing. If you're going to change it, put it in writing. So y'all return the child when you're supposed to, and you know what
I didn't put it in writing, but I did text him and tell him that. So, I mean, it's not in writing, but it's in text form.
I presume you'd have to take it back to court to change it or something
Well, I didn't realize I had to take it to court to do all of that. I mean, if I did know that, I would have done it. I would have done it the right way.
You ask a good question, but that visitation is one thing, possession is one thing, and legal custody is another. But I can make my ruling based on the facts I heard here. And this is not a legal custody fight because I can't have one. Nobody filed a modification for legal custody. This is a possession fight about whether he had her, he didn't have her, how much he had her, and whether that impacts the child support. That's what I'm trying to decide. And whether I do temporary or final, I don't know yet, Ms. Brown. I'll hear testimony. I'm going to consider that your closing argument, that you don't agree with, that he has a 50-50, that you don't want to do what you said you'd do 8 years ago, and that you want the full guideline amount of $607. Is that right, Ms. Hernandez? That's your position?
Yes.
Okay, I got it. So I'll hear further argument from the lawyers. Ms. Campos going first?
Yes, Judge. First, I'd just like to say that the controlling visitation schedule is the standard possession schedule. I understand that they had an agreement prior to that final order being done, but that they showed the date on it. That was April 16th. I think that it said of 2016. This final order was done September 9th of 2016, and it was signed by all parties. So the controlling visitation schedule is the standard possession schedule. Guideline support is
Except it
$607.
says you can do whatever you can by agreement.
It
does
certainly does, Judge, but when there's a disagreement, it goes to the standard possession schedule, and it sounds to me like parties are disagreeing a lot on the issues of visitation here. Now, I would generally ask for guideline support, but considering the visitation schedules they've been actually exercising, I think a deviation might be warranted in this case. But I just want to emphasize that, again, the standard possession schedule is the controlling visitation schedule that's in place at the moment. That agreement was done prior to that final order, and the final order that was filed with the court, it was signed by a judge. I think that is the controlling schedule that is set out. And we're also asking that
Tell
the
me
court...
again before you move on, the visitation, the standard possession order, which is, you say is a controlling order from 2016. That's different from the current standard possession order. So it was a lot less.
It was the non-expanded standard possession schedule. So he had the right to possession 6 p.m. on the first, third, and fifth Sunday, ending at 6 p.m. on the first, third, and fifth Friday of each month, and ending at 6 p.m. on the following Sunday. So it's just the non-expanded standard possession schedule. But that is not, as you said, Judge, that is not before the court. Changing that visitation schedule is not before the court today. So
I'm just trying to interpret what you got there because it's different from what we have now. Just double checking that. Okay, moving on to support the possible.
I'm just going to put that to the court, ask the court make a determination as to this. $607 a month is what guideline support is. And that's, taking into account that it's a standard possession schedule. So I think that would be fair. But I also do think that this is a case where a deviation could be warranted since parties have been exercising, it seems, a different schedule. And I would also ask that the court
would be left up to me. You don't have a position on how much.
I do not have a position, Judge. Honestly, I'm going to leave that up to the court, considering the back and forth on what the visitation actually looks like. And generally, I would just recommend guideline support, but considering what I've heard from parties, that's why I think a deviation could be warranted. But I will say that it is the standard possession schedule, like I said. So, and we're also requesting that the court make a determination as to the non-disclosure of mom's phone number to dad. And
I think meets the burden of the family code.
I'm not taking a position. I'm just asking that the court make a determination as to whether it should be disclosed or not.
Well, I know I need to, but I thought you just said you recommended it, or no?
Oh, no, Judge. I'm just asking for the court. I'm not recommending either way. I'm just asking for the court to make a determination.
Okay, I'm sorry, I misunderstood. Okay.
And we are requesting final orders at this time. It sounds to me like we have all of the income information necessary to calculate.
What do I do? Because if it's a mod, don't I have to address insurance too? What do I do? Leave what it is, which I'm not sure what it is, or change it somehow, or I'm not sure what
parties agreed to have dad continue to carry the health insurance, and the costs of that were taken into account
That was such a
And
long
the-
time ago. I didn't remember that. Okay, so he's carrying it, both medical, dental, and he'll continue to carry both.
Yes, Judge.
That's what was agreed. That's really not even a modification. That's already ordered.
Thank you. I just didn't remember that since that was now a couple hours ago. From a while ago. Ms. Brown, you're next.
Your Honor, I know it's not a determination for modification of possession. We are asking for any type of deviation, obviously, based upon the excess possession. I do believe that the possession is 50-50, sometimes even more than 50-50 on behalf of the father. And I don't want the mother to feel like she needs to deny the child and father possession time so she can have a financial advantage. I'm hoping she sees it still in the child's best interest to continue with how they've been sharing this child. She at one point only all she wanted was $50 a week to help her out, and which is $200 a month roughly. But I would ask you to not modify this order at this time, and I'd ask that we have a temp order if everybody wants to do that, so everyone can get their little calendars put together if that's really what they want to do. But if you do go final, I would ask that you definitely do not do guideline support because of the excess possession this father has been exhibiting throughout since the last order. And then while that agreement they reached before they came to the AG's office is preceding that new AG order, I think everyone understands what unrepresented people don't understand. And the bottom line is that these people have been following the heart and spirit of that agreement they reached ever since that order was entered. I think that's indicative of what has been going on. They might get mad at each other and say, well, you can't have her for an extra day this week. But every week, this respondent father saw this child because he works every week. He has days off every week. And that is when the mother was allowing him to exercise his possession of the child. So I do think we're at a 50-50, maybe even a little bit over 50-50. So they agreed back in 2016 that they were doing this halvesies and that child support was not warranted. I would ask that remain the same situation. If you feel that circumstances might have changed since that date, because it was 8 years ago, mom might need a little bit extra support that she didn't maybe need back then. But you take it in consideration that all she was asking him for was $50 a week when he didn't pay. And so then she came to the AG's office for some help.
So now if I were to do that and I considered whether they had disparate incomes, where would I land? Because I didn't hear any evidence on that. Ms. Campos did it already.
Mom makes more than dad does. Her monthly gross is $49.16. I divided what she said her annual gross was and divided it by 12. So I think she does make a little more than him.
And what's your dad's gross? Did you tell me already?
We know the net, Ms. Campos will have his gross.
The gross monthly, Judge, is $3,754.40.
Yeah. And my client is not in any way asking for any type of support, obviously. Not been pled, nor is it his desire.
So I can't offset it because she makes more. But
Right.
Okay.
And he is providing the health and medical for this child at his own expense.
That rate was $148 a month.
Correct, Judge. That's the dental plus the medical combined.
Yes.
Do you know, Ms. Hernandez, do you make more than him?
Yes, ma'am, I do. He has been at that job and forever already. I've tried to, I was at one job at one time and I moved to another to make more money because I wasn't getting the help. So, I do what I have to do. I have a second job so I can make extra money,
I didn't include her second job, Your Honor. I think you tend not to make people work an extra job. So I didn't include that.
Yeah, I do it to support my habit, because I like to buy things. So I do it for my own.
It occurs to me that it doesn't matter what I do. I'm going to either get appealed or you're going to file a new lawsuit to change the possession schedule or even custody schedule. And this is going to not be the last day in court today, is my gut instinct. But I don't predict it. I can't rule on the future. I can only rule on what I have here today. So I'm going to, let me double check everything. Well, there's no issue on the medical, so dad provides the medical and dental. I'll approve that. There is an issue on child support. Let me leave that for last. There was also an issue on non-disclosure. Based on what I've heard, ma'am, I don't think you qualify under our current law. And I'll tell you this, that's not the end of the world that he knows where you live. If he does something that he's
I
not
mean, I don't,
doing, you call the cops. You
right.
the police report, you file charges, you do whatever if he's really truly threatening you. Now
I was just tired of
I know,
the
man.
cussing me out, you know,
There's
like,
nothing you can say at this point that I haven't already heard and considered. So if something happens, I say there's laws on the books, this thing that we didn't disclose your address. And Mr. Ramirez, I don't think you're gonna be stupid enough to go harass her, harm her, threaten her, send somebody to do it that can be traced, that would be traced back to you, just to for your ego, and then still have your child more than half. You get nowhere that way. And you know what happens. You end up in jail or prison. And I assume you're not going to do anything stupid. I'm telling you not to do anything stupid because I don't see that you've been doing that yet at all. Or
I haven't. But ma'am, I'll tell
she
you.
thinks you have. There's something
No,
going on that she interprets that you're not interpreting because you wouldn't be here otherwise. You get it? I don't want
right.
you to hear your side too. I don't want to hear anymore. Now you got to hear me. So I'm telling you, don't be stupid. Don't do bad things. Don't talk to each other. In fact, would either of the lawyers object if I ordered some kind of general restraining order on them or what?
A mutual injunction, I think, is appropriate, Your Honor, to make sure that they
Just
like the standard orders.
How not to talk to each other or threaten or harass each other. You can put that together, Ms. Brown?
Yes, I can find that language and send it to Ms. Campos.
And then add the Children's Bill of Rights where from Hays County or if this county has one, whatever. So y'all can read y'all are better than those parents I see in here, which is frustrating to me because you shouldn't be making these arguments and asking for non-disclosures at this point and me having to put injunctions in the order. If you're co-parenting a 9-year-old, for God's sake. So I expect you to behave better. You're going to get caught if you don't because the authorities will be involved or you'll be in another court with another judge where all these allegations come out and maybe even proof. Which I never get here. I get he said, she says here, but I'm used to it and I will rule accordingly. However, I'm subject to appeal. You can go to district court and get an appeal me if you think I'm wrong, or you can go to another court and resolve your custody and possession schedule on today's set of facts and desires and whatever, and good luck with that. But you have the right to do that as well. That's not going to be my job. You don't end up here doing it. We don't do a custody mod unless the other parent already has months of possession full time. So don't expect the AG to do it for free, sir. You may have to pay Ms. Brown or somebody else to do it. And Ms. Hernandez, if you're trying to do it, you'd have to put the money together, figure out how to do it yourself. And that's a hard thing to do and get to court to stop the insanity that y'all have now created for yourselves. Okay, I'll quit speechifying. Injunction, Ms. Brown, Children's Bill of Rights, Ms. Campos, you'll find and add. And then on the issue, and so non-disclosure is not being granted. So this order will disclose everybody's addresses, phone numbers, phone numbers, and email addresses. On the money, I was going to be, it's real easy. I'll just figure out that he makes more, she makes less, and give you the difference, ma'am, because maybe you do need a little bit more help. You make more. However, apparently, I don't know if there's allegations, there's some evidence, just because it's testimony, and I think it's undisputed testimony, but I'm going to give her a few dollars of help, Mr. Ramirez. If you can do it, great. If you don't agree with it, Ms. Brown could go up to district court and appeal me. I'm going to do what she originally wanted and what you, I think you thought you agreed to, but ended up not doing. $50 a week times 52 weeks a year is $2,600 divided by 12. That comes out to $216.66. I'm going to say child support from dad is $217 a month, starting September 1st. That might give you the wiggle room to give up that tiny job that you don't get money from, or do whatever you need to do. But you make more than him, so I can't give you a lot more, ma'am. If the facts were different, this might have been a different outcome, but they're not. But I will give you what I think you said you could live with and could handle, and that based on his income. So child support $217 a month starting September 1st. I'll waive court cost. I think they normally would have gone to Mr. Ramirez, but given that, I'll just waive them. For good cause, if you need a reason. And then what else? The custody and visitation is not an issue, so I'm not addressing any of that. Does this cover the order, Ms. Campos?
Is it the final order,
It's
Judge?
Final order. I don't think I could do anything further. They came back with calendars or more testimony or more witnesses. This is what I do. This is how I do it. And if you don't agree with me, you appeal me, or you go to another court and fix the problems you're really having, which is the possession schedule. That you're no longer agreeing to, Mr. Ramirez, because it's an old possession schedule. You may be entitled to a lot more under the current scheme. So anyway, yes, it's final. You understood that too, Ms. Brown? Any questions?
Yes, and you already gave everyone the de novo warning and all that good stuff. So we're good.
I did. Mr. Hernandez, you got 3 days from the time you get the signed order from me in which to appeal this. You gotta have it. Well, I'm gonna tell the AG to put the 1-page de novo appeal rights, so I don't have to talk anymore and I can start the other case. But it's tricky and it goes fast. And so if you want to appeal me because you don't agree with me, you need to start talking to somebody or going to a law library to talk to whatever lawyer's on staff, or get a consultation with a lawyer to figure this out. But you got 3 days from the day you get the signed order to file something in writing, and then 30 days after that to get a court date in court with copies to everybody. And I'm just giving you the generics. I'm not trying to say that that's all there is. You go figure it out. You have the right of appeal. You want to go to another court. Then that'll be the end of this hearing. State's going to draft the order. You'll send the injunction language, Ms. Brown. And with that, the state will send out the proposed order to everybody. So you have, I think 1 week. I'm giving you 1 week, Ms. Campos, to try to get everybody to sign it. If you don't sign it, they can turn it into me next Friday and I'll sign it without you all, since it's my order and nobody agreed to it except me. And since I'm rendering it as my order anyway. So Ms. Brown, if you're on jury trial, you have something going on, you can't get to it, just call the AG and ask for a few more days. I'm okay with that. But
Okay.
You need to sign it when you get it. If you choose not to sign it, just don't do anything. They'll submit it without your signature if you don't agree with it. Okay, thank you.
Can you put me and Ms. Campos in a room together so we can
I'm
get
going to
stuff done?
ask the AG to do that for me. And yes, I'll get
Okay.
ready for the hearing. Thank you, folks. Good luck to
Thanks.
everybody.
Thank you, Judge.
Protect that child.
Thank
She
you,
does
Judge.
not need to hear this argument between you all. Leave it with the adults and the courts. Thank you. Bye.